The news is reporting that the defense for Karen Read is doubling down. If there is one expression that seems to have taken over the media landscape lately, it's doubling down. Deriving from the game of blackjack, doubling down has taken on a figurative meaning over the past couple of decades to engage in risky behavior, especially when one is already in a dangerous situation. So why is the defense motion so risky and dangerous? In this video, we will discuss this and the competing hurdles that the judge will have to decide on what to do next. Let's listen to the rest of the news clip, then we'll get into it and the breaking news since this latest defense reply.
Yeah, they just filed another new motion arguing the judge declared a mistrial without warning or really asking for objections.
So NBC 10's Manoj Kwangwari live right now in Dedham with the latest on all of this. Manoj, tell us more.
Did another push to dismiss crucial charges against Karen Read. Her lawyers now saying they were, quote, given no opportunity to be heard before the judge presiding over the case ultimately declared a mistrial. Now, Karen Read is facing 3 charges: second-degree murder, leaving the scene of a crash resulting in death, and manslaughter while driving under the influence. In a 10-page document filed yesterday, her lawyers once again asking the court to dismiss the second-degree murder and leaving the scene of a crash charge, claiming now that 4 of the 12 jurors have come forward saying that during deliberations, the entire jury agreed Karen Read was not guilty of either of those charges. Therefore, it would be against the Constitution to prosecute her again in a potential second trial.
And the reason it would be against the Constitution is because the Fifth Amendment, among other liberties, provide, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, meaning would it be fair to retry Karen Read on charges that a jury already acquitted her for? The Commonwealth prosecutor did respond to the defense's first motion, basically saying that the jury was clearly at a deadlock and the defense did not object to the mistrial, nor was a verdict reached. Thus, the judge made the right call to declare a mistrial, and therefore, after they were dismissed, the jury cannot be called back for the reasons that the defense are giving. And because of this well-established protocol that jury deliberations are done in private, but we'll talk about that concern of jury deliberations being secretive, as they are not part of the court record, and as such cannot be recorded. But should they be? As this devastating consequence is that now jurors are alleging they had reached a verdict on 2 of the charges, and indeed were hung on the second charge. And let me just tell you a little bit about the article I read, Sacrificing Secrecy. The author questions whether it would be fair to record jury deliberations, as the U.S. Constitution does not compel the secrecy of deliberations. So the legislators and the courts could change the practice today if they were so inclined. And the article is really interesting because if you think about it, if the jury deliberations were recorded, then for sure in this dilemma that we're in with the Karen Read case, they could have just simply checked the recordings. And let me just read you another great point that this article makes. The U.S. Supreme Court has heralded the jury as an inestimable safeguard against the corrupt or overzealous prosecutor and against the compliant, biased, or eccentric judge. Thus, when bias infiltrates jury deliberations, it undermines public confidence in the fairness of our system of justice. Anything that shakes confidence in the jury system is deeply troubling because the integrity of the jury is critical not only to our system of justice, but to our entire democratic structure. I wish I could read you the full article from the Georgia Law Review, but it is a PDF, so if you want a copy, please email me and I will send it to you. Now, this is my opinion, but I do have concerns. The Commonwealth of Massachusetts is being overzealous in seeking a prosecution against Karen Reid. Given the DA's comments before the trial, let's have a listen to that. It's a clip, and if you want to listen to the whole clip, I'll leave a link in the description area below. But it's from CBS Boston News on just how the DA spoke about the lead investigator. Though, as we saw in the trial, the evidence presented played out very differently. Then straight after that, I will play the latest news regarding State Trooper Michael Proctor.
State Police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
Michael Proctor, the lead investigator in the Karen Reid case. Boston 25 News reporter Lisa Pappas, you asked an attorney about the impact the move could have on a possible second trial.
Yeah, well, our legal expert says this can't be good for the prosecution moving forward. Trooper Proctor had just been transferred here to Troop H here in South Boston after he was relieved of his duties at the DA's office. But now he can't even work here as the investigation into his conduct continues.
Proctor was the lead investigator in the Karen Reid murder case. State police held a duty status hearing Monday and found there was enough evidence to take him off the job without pay for now.
They wouldn't have done that unless they really thought he did something egregious.
State police say they started investigating Proctor's behavior after his concerning testimony during the trial. When he took the stand, he read derogatory text messages he had sent about Karen Reid while investigating her boyfriend's death. At this point, the Norfolk County DA still plans to retry Karen Reid after her case ended in a mistrial last week. So how could Proctor's suspension affect the next trial?
Yeah, there's no dancing around the fact that by the time this retrial happens, he could very well be completely fired or even facing certain kinds of charges against him for his behavior in the investigation. So it certainly is agreed by all that he's going to look bad if he has to testify again.
State police say the internal affairs investigation on Proctor will continue. Once that ends, we'll find out whether or not he will be fired, and he could even face charges. Live in South Boston, I'm Lisa Pappas for your local station, Boston 25 News.
And the breaking news is that yet another juror has come forward. Juror E confirmed they decided Karen Reid was not guilty on counts 1 and 3 and were undecided on the lesser charges, which were on count 2. Now, I went through those charges, and so please check out that video. And why would the DA want to go forward with this in any event? As we heard that Trooper Proctor had some serious issues with his testimony, and I think it's worth going through some of the highlights because it's not just a few simple errors.
Second, but shift gears to the Ring video footage. You've already testified that there were several hundred Ring videos from One Meadows from both the facing the driveway and the front door camera, correct?
Yes.
As the case officer, you obtained and controlled those Ring videos from One Meadows from the moment that they came into Massachusetts State Police custody until they were handed over to the Commonwealth, correct?
Yes, they were archived.
You drafted the search warrant for the Ring video access records, correct?
I did.
You obtained the warrant returns once those search warrants were executed, correct?
I did.
You took possession of Mr. O'Keefe's cell phone physically, correct?
Yes.
And you had access to Mr. O'Keefe's Ring account in that cell phone, is that right?
Correct.
You indicated that you reviewed several of the videos on his Ring app on his cell phone, is that right?
Yes.
So you obviously had not only possession of his cell phone, you had possession of his login account information to get into the app on his cell phone. Is that right?
I don't believe we had the password. We had his email account associated with the Ring.
Which means some way or another, you could get access to the Ring videos.
Correct.
And watch those Ring videos on his app, on the phone.
Yes.
Which means you had full access to the app. You could keep videos, you could save for later, you could delete videos, you could do anything you wanted to within that app, correct?
Yes, those are the capabilities within that app. I reached out to Ring several different times. They informed me if a video is deleted, there's no digital footprint of that. It's essentially kind of gone forever.
And do you remember what the DA said about Proctor not having any connections to the Alberts? Let's find out if he did or not.
A Boston cop whose family you were actually connected to, correct?
Loosely.
Chris Albert, loosely.
Yes.
Julie Albert, loosely.
Yes.
Colin Albert, loosely.
Yes.
Kevin Albert, loosely.
Yes.
Loose enough to leave his badge and his gun in your cruiser after a night of drinking, right?
Objection.
Sustained.
You agreed in your group chat that you needed to, quote, make this cut and dry because another cop was involved. Those are your words, right?
Objection.
Where is this?
This was referred to in earlier text messages, group chats this morning.
So is that right? Did you say that, sir?
I did text that. I don't know if it's in the exact context. But yes, those were my words.
Group chat.
Yes, that was in the group chat.
Your friends wrote this whole thing, in their words, stinks, correct?
Yes, I interpret that as a joke.
You believed, Trooper Proctor, that your life would be much easier if Karen Reed was just dead, didn't you?
Objection.
I'll allow it.
No. Like I had said, it was a figure of speech. My emotions got the best of me based on, the fact that Miss Reed hit Mr. O'Keefe with her vehicle and left him to die on the side of the road. So my emotions got the best of me with that figure of speech.
Passenger side taillight, which prosecutors say was damaged after Reed allegedly backed into John O'Keefe and killed him.
I testify that this is a accurate scene.
But under cross-examination, state police investigator Yuri Buhenik confirmed the video is actually inverted. It shows not the passenger side, but the driver's side of the SUV. At one point, it shows the driver getting out.
Not once did you mention that this video is actually completely inverted.
In the video, the word police appears backwards on another vehicle parked in the garage. So does the number 4 on one of the garage's overhead doors. Defense attorney Alan Jackson believes it was no accident.
The timestamp across the bottom is not inverted, which means somebody had to put that on the inverted, the manipulated, the altered video on purpose.
Here is the video again after we have uninverted it. What is in fact the passenger side taillight is out of view, and there appears to be somebody standing near it.
Who's the guy in the watch cap, in the winter cap, back there by that right rear taillight, the entire time by himself?
Guess who the defense alleges was behind Karen Reed's SUV, shattering the taillight?
Appears to be somebody standing near it.
Who's the guy in the watch cap, in the winter cap, back there by that right rear taillight, the entire time by himself? That's Proctor.
Proctor is Trooper Michael Proctor, the lead investigator on the case. Now, the defense has said that he is the one who broke the taillight as part of an effort, they say, to frame Karen Reed. I did reach out to the district attorney's office about that inverted video. They said they would not comment.
Another issue creating a problem for State Trooper Proctor was in his report, he admitted he entered the wrong time. He collected the SUV from Karen Reed's parents, saying it was a typo. Let's listen to part of a news clip from Karen Reed's brother. Listen closely to the times, as they have evidence that, in my view, matches Sergeant Barrow's testimony, which I'll play straight after that, so you can line up the times.
State police reported towing the Lexus to the Canton police station at 5:30 p.m. Nathan Reed says daylight video from his dad's house shows the car was taken more than an hour before that.
They confiscate Karen's car at my parents' residence in North Dayton.
at 4:16 p.m. And somewhere in the neighborhood of 5:30, 5:45, Mass State Police CERT team comes back to the scene. They search the scene then with 2 feet of snow, and pieces of a tail lamp are found on top of the snow.
So, did State Trooper Proctor break the taillight? Was Karen Reed's taillight broken or cracked before State Trooper Proctor collected her SUV from her parents? Let's listen to Dighton Police Sergeant Nicholas Burrows, who met Proctor there at her parents' place at 3:10 in the afternoon.
You received that call at about 2:30. Do you know specifically who you spoke to around 2:30 in the afternoon?
Trooper Michael Proctor.
And what, if anything, did they indicate to you as far as where they were or when they felt they would be arriving in that area?
Trooper Proctor advised me that they were heading, I believe, from Canton, and once they were about 10 minutes away, they would recontact me so that I could meet them at the residence.
And subsequently, later in that afternoon, did you receive further contact from Trooper Proctor?
I did.
And do you know about what time that was?
I believe the first phone call was around 3 p.m. that he had called me and said that they would be there in about 10 minutes.
And upon receiving that call, what, if anything, did you do?
I had contacted, Trooper Proctor had asked me to contact our tow company to have them meet us at the residence as well. And I said once I hung up with him, I would contact the tow company and then respond to that address on Country Hill Drive.
So you had reached out to the highway superintendent to have someone come out and plow the driveway, correct?
Correct.
And do you know about how long it was between the time that you made that call and the time that the plow driver came out to clear it?
Less than 10 minutes.
And the sort of clearing of the driveway and the process of that, do you know about how long that took?
I'd say another 10 minutes or so.
And as far as the time that the troopers went into the house, at some point the troopers obviously came out of the house, correct?
Correct.
Do you know about how long it was that they were inside of the house?
More than 30 minutes, less than an hour.
From where you're standing at the point of the garage, was what part of the vehicle was facing you? Was it the front of the vehicle, the back of the vehicle, the side of the vehicle?
I was looking at the left side of the vehicle.
And at some point, did you make any observations of the right rear part of that Lexus SUV?
I did.
And what, if anything, did you observe about that area of the vehicle?
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked, and a piece was missing, but not completely damaged.
And then beyond the taillight area of that vehicle, what, if anything else, did you observe as far as damage to the rear passenger side area?
Like a dent on the rear quarter.
Well, this was jaw-dropping testimony in the Karen Reed murder trial. The lead investigator read personal text message that he sent to friends, calling Reed a whack job and far worse. WBZ's Christina Rex was in the courtroom for all the testimony.
Zero. Absolutely zero impact on this investigation.
That is what State Trooper Michael Proctor tried to convince the jury about his relationship with some witnesses in this case and about the unflattering personal text messages of his he sent about Karen Reed as he investigated her for murder.
She's a whack job. See.
Objection. So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Proctor is embarrassed, as he told the jury several times.
The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
So what's your views on jury deliberation being secretive? Do you think there's enough evidence if enough of the jurors come forward and say that they had decided, but they just didn't know if they should tick the box? And what do you think about this unjust risk for having to go through another trial, given that Trooper Proctor did such a terrible investigation? Is the defense attorney Alan Jackson, AJ, taking a gamble on asking the judge to listen to the jurors who said they acquitted Karen Reed? And now can you see why they are doubling down? Wow, what a mess this case is in. Ziggy and I need a drink. What do you need? Can we get you something? Thanks for watching. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.